Section 33. Bail, continued amount thereof, etc. We have adverted to the provision in Section 7 of the Act, affording security against any protracted detention of an innocent man, though some matter of treason or felony be expressed against him in their warrant, by way of evading the remedial provisions of the Act, the judges not being empowered to inquire into the truth of the facts contained in it. Another evasion might have been found in the bailing of prisoners. The Act is silent upon the subject of the amount of bail, and it might easily have been made a dead letter, says Mr. Amos, by an abuse of the discretionary power by it of bailing, the party imprisoned, when brought before a judge, being entitled to be set free only on condition of being bailed, the amount being left to the judge's discretion, who might have none. Since the reign of Charles II, however, an important security for liberty has been gained in the declaration of the Bill of Rights, that excessive bail ought not to be required. The same learned author mentioned above says, considering the ferment of politics in which the Habeas Corpus Act was passed, it will not be surprising, if, after the lapse of nearly 2 centuries, that Act may appear open to some criticisms, and may have been somewhat dilapidated by time. The provisions of the Act turn very much on the distinction between felonies and misdemeanors, which, in the reign of Charles II, was a clear and sensible distinction, for, in that reign, felonies were almost synonymous with capital offences, and the expressions felonies and capital offences are often used indiscriminately by Sir Matthew Hale. Felonies were generally not bailable, at least by justices of the peace. Misdemeanors were almost universally 80. In the present day, 1857, felonies are generally bailable by justices, and a series of misdemeanors is not bailable of right, but only at discretion. What occasion, then, is there for summary and extraordinary relief in the case of those misdemeanors, the perpetrators of which are not now, as of common right, entitled to be set free upon bail? And on the other hand, what provision does the Act contain for forcing on trials of persons committed for such misdemeanors as are bailable only at discretion? Perhaps, in this respect, the Habeas Corpus Act partakes, in some measure, of the crust of antiquity. 1.